So intellectual property is a critical part of product development. You don't want to put all this effort and time and money into developing something only to find that 6 months later it gets copied by someone else and they do it bigger and better than you can because they're an existing company with larger marketing budgets. Now, the good news is you can stop that happening, and the mechanism to do so is intellectual property protection. Now, let's look at how this fits with the overall product development journey. Well, basically, early on in the beginning stages, you're going to want to do a patent search potentially to look at whether someone else has already protected the same idea or not. And this can eliminate ideas that actually you couldn't protect, or worse, if you developed and launched would infringe someone else's IP early on before you end up spending too much money on it. Now, assuming that patent search comes up clear, then some initial development work and some concept design will probably happen. And then it's best to get a patent opinion from a chartered patent attorney. And if you're working with us, then we can put you in touch with people that we trust, who we've worked with for many years, who will give you often a free of charge initial opinion on what can be protected with your idea. Now, that's often a patent, but it may also be a registered design. From there, what we can then do is develop the idea further and prototype it. And once the core functionality has been proven, that's the time then to go back to a chartered patent attorney and start looking at getting your patent draft sorted out and filed. I wouldn't do it too early because things might change in the prototype, or new ideas for how we create particular solutions could come up that you would want to be part of that patent application. So it's really important to keep your idea confidential right the way up until you've got your patent filed, because otherwise you can lose the right to that patent filing. If you reveal it under a confidentiality agreement, then that's okay. Do get in touch if you want more details about that. So moving forward from there, your registered design application, which protects the look of the product but not the functionality, that needs to happen as late as possible in the process, because little tweaks in terms of the look of the design can happen right the way up to production. And what you don't want to do is have to file that twice. The other thing that's worth bearing in mind is that you may need to do some additional safety checks on your product, or some tests and certification, for example, if it's a baby product, and assessing the risk of certification standards and what's required can also be a key part of the journey. Now, make sure you check out this video, which is a deep dive into the intellectual property protection process. It goes through costs and timescales and exactly what's involved. So do watch that now.